You ask that witness the first question. Say to the judge, the following stipulations have been reached, and put them on the record. Go on again and say, request for admissions has disclosed the following items, and list each and every one of them. That way you do not run the risk of a judge sitting up there thinking he's forgotten the crucial element of his case. The judge knows in advance that he's not going to hear evidence on that subject matter, and he can listen more appropriately to evidence that he is going to hear. This is how you use your discovery product, particularly if that discovery product is a request for admission. We talked earlier about having documentary evidence and having the originals there in court. Remember that the evidence code provides the basis on which documentary evidence is to be exhibited. It doesn't give you any comfort to have all of your original documents in court without their custodian. Because unless you have a stipulation in advance that the foundational evidence will be waived as to all of those documents, you are going to find your case doesn't exist when none of your records can qualify as business records exception to the hearsay rule. You've got to take that into account. And again, we cannot stress enough, if that stipulation has been made to waive the foundation, get it in writing and make sure that the judge is aware that that's been there. Remember that with your documentary evidence, there is a great deal of difference between objecting to that piece of documentary evidence on the grounds that it fails to qualify as a business record, an objection which is, in my mind, impossible to win, and the argument later, that while it's true documented as a business record, it doesn't say anything. I see a great many arguments made about objecting to business records on the ground that they're not really business records. And I can't remember a case in which someone was successfully able to keep them out on that basis.
Warren, do you have some comments on this presentation of evidence?
First of all, demonstrative evidence in a family law matter can be very significant. Take, for instance, the issue of spousal support. If you're able to present by picture the family home, showing rooms, their furnishings, not for the issue of dividing the personal property up, but to show what that lifestyle was, you're able to convey to the judge a picture that words won't meet. You're asking a court to order one party to support another for substantial periods of time. And those type of pictures present a very graphic way to demonstrate how the parties live their life. Recent pictures of a family vacation showing how the parties spent their leisure time. It makes it a lot more possible for you to have a financial declaration that shows a figure of $300 a month for money accumulated for a vacation so that the supported spouse can take the children on a vacation. It doesn't come in a vacuum when you have that type of demonstrative evidence. Charts that show what the tax effect could be of various potential dispositions of assets. That is worth a lot of time and could very well be very significant in the distribution of assets. The possible allocation of assets showing the values and, again, bringing to the court's attention the fact that the court is directed to make an equal division, except in those minor circumstances where the family home is the only asset. I think that we are beyond the days where the short cause matter involves a nominal amount of property. In the last couple of years, the family home in the Bay Area, the median price is $100,000. You often could be dealing with an asset worth a great deal of money if you have a case that you're going to dispose of in 2 or 3 hours. You want to present to the court a picture of what the life was like that your client was leading so that you can, if possible, either perpetuate that lifestyle or prevent a lifestyle that is better for a client than it was while they were married. And you must remember, we are talking about a court trial. That famous picture of the jury gasping while the judge is directing the jury to ignore the remark made by the witness. This doesn't fly in a case involving a judge. You're dealing with a sophisticated listener. As a result, the expertise that you might have in those clever objections to questions are very good for the first objection or two, but it wears awfully thin. You have to remember that the judge might have 2 or 3 cases, and while you're making valid objections that really don't affect what's being told to the judge, you're not really scoring points. Your client might momentarily think you're brilliant, but you're not getting anywhere with the one person that you want to convince of any fact, and that's the judge.
I think, however, there's one caveat we have to give you in talking about that. There are certain lines of objections which are going to be crucial to your case. If you have had a request for admission admitted and you get a line of questions in contravention to that admission, you've got to raise that issue of relevancy. If it gets up to the appellate court, you may find a waiver. The other circumstance where I feel you have to raise it is when you get the objection for facts not in evidence. It may well be that by your discovery, you have been able to ascertain that they cannot establish the preliminary facts necessary to raise a line of questioning. An example would be in a contract case where there is an allegation of a breach of warranty, particularly a breach of an implied warranty. If you note in the sample pretrial statement we have from the plaintiff, one of the issues in there is an issue of implied warranty of merchantability. And the argument was it was a sale by sample. When you get to trial and they want to raise that, if they have not been able to establish by preliminary facts that it was not a sale by sample, and you let those questions in, you may have waived your position. So when you've got a line of questioning that requires certain preliminary facts to be established before that line becomes relevant, you have to jump on it, and I think you have to jump on it the first time it comes up.
Aside from evidentiary matters, Richard, what kind of motions can be made profitably during trial?
Well, I think the most embarrassing one is the one I alluded to earlier. It's a motion under Section 631.8 CC2. Now, many people tend to look at that motion as being a jury motion because it talks about directed verdicts. But that motion can be used in 2 ways in a non-jury case. One, it of course tells the other side that they have failed to produce all of the elements of their cause of action, and therefore they have failed to prove the case and should be non-suited out. And so I said in the beginning, remember to read your own pleading, because if that motion is granted, you have rested your case in peace by then. The motion is made, you can't reintroduce it, you can be out of court in a big hurry. But there's a second use for 631.8, which can be very profitable in shortening the defense side of a trial, and that is for a ruling on some issue. If there has been an allegation which would lead to punitive damages, and you can get the judge to rule that they have failed to establish the necessary basis for those punitive damages, you can shorten the defense by several hours of testimony. As a practicing judge, which way do you get that motion most often?
Oh, I get the motion from the defense, and it seems to me to become much more frequent lately that the motion is made, particularly the motion for partial judgment. And so far as I know, judges are not reluctant to grant the motion. They're as interested as counsel, probably more interested in shortening trials and disposing of them as early as possible. And there's little purpose in putting the defense to the burden of presenting a case on an issue that the judge is satisfied he can't possibly rule in favor of the plaintiff on. The requirements have been changed in recent years so that it doesn't have to be a situation in which the judgment could not be for the plaintiff. It's simply put to the trier of fact, the judge, to make the decision at that time without prejudice to the defendant being able to put on his case, putting to the judge the opportunity to decide whether on the evidence as presented he would be inclined to render a judgment for the plaintiff. If he feels he wouldn't, then the motion ought to be granted.
One of the common things that you will find, and something you should of course do with your plaintiff and you're hit with that motion, is ask the judge to take that motion under consideration until after the defense evidence has come in. Most judges will do that if there's any kind of doubt in their mind at all about whether it should be granted. Finally, don't forget that that motion is still sitting out there.